Hi, Assalamualaikum, and very good day to Sir Eko Nagwib. My name is Ahmad Rahin Ainan bin Musa, and student ID is 2023458114. So today we're from Group 3, and we will present topic director, and we already choose July 2023 and December 2013. So let's start with July 2023.
Question 3. Ravi is a director of a property development company, Real Land Sendirian Berhad. He was given the task of negotiating the purchase of a piece of land in Bidor Perak with the landowner Maju Berhad. During the negotiation process, Ravi was offered a commission amounting 25% of the purchase price. Ravi accepted the commissions and the sale was completed between RLSB and Maju Berhad at a price which was over the market value to enable Maju Berhad to absorb the commission paid to Ravi. In another occasion, Ravi had also received an information regarding another land deal in Ipoh, Perak. Pursuant to the information, Ravi and his fiancée Samantha incorporated a company named Mikasa Sendirian Berhad. MSB purchased the said land in Ipoh and developed it, resulting in a huge profit. RLSB seeks your advice on the legal position with regard to the above matter and what are the right and remedies, if any, that the company has against Ravi. The issue are whether Ravi, as a director of Real Land Sendirian Berhad, has breached his statutory duties under the Companies Act 2016 and his fiduciary duties under common law, and whether RLSB has any legal remedies against Ravi for these breaches. Law. First, statutory duties under the Companies Act 2016. First, under the Companies Act 2016, directors have to follow several important duties. Under Section 213, Clause 1, directors must act in good faith and always think of what's best for the company. Section 213, Clause 2 says they must show reasonable care, skill, and diligence in doing their job. Then, Section 218, Clause 1 prohibits director from using their position for personal gain or to harm the company. Section 218, Clause 2 says they can't use company info for personal benefit or to help others. Lastly, Section 219, Clause 1 requires director to disclose any interest they have in a transaction related to the company. 2. Conflict of interest. A director cannot take advantage of their position to benefit themselves or anyone else. Even if the company doesn't lose any money, it's still wrong if there's a conflict between personal and company interests. Let me give an example from the case Abidjan Railway Company versus Blakey Bros, 1845. The court decided that it doesn't matter if the deal was fair or honest. The moment there's a conflict, the director is in breach of duty. 3. Fiduciary duty, loyalty, and corporate opportunity. Directors also owe what's called a fiduciary duty, which means they must act loyally and put the company first. One part of this is the corporate opportunity doctrine. Basically, directors cannot take businesses opportunity that belongs to the company for themselves. A clear example is the case Regal Hastings Limited versus Gulliver, 1942. In that case, the directors personally made a profit from buying shares in a subsidiary because the company didn't have enough fund. Even though the company benefited, the court said it was still a breach because they didn't get proper consent. So, to sum up, directors have to act honestly, responsibly, and always prioritize the company. The law is very clear: no personal gain, no secrets, and no conflict. That's what keeps company fair and accountable.
Interpretation. In the first scenario, Ravi, acting as a director of RLSB, was assigned to negotiate the purchase of land in Bidor. During negotiation, he accepted a secret commission of 25% from the seller Maju Berhad without informing RLSB. As a result, the sale price was inflated beyond the market value to allow Maju Berhad to pay Ravi's commission. This conduct is clear breach of several statutory duties. Firstly, Ravi violated Section 213, Clause 1, CA 2016 by failing to act in the best interest of the company. Instead of secure, Instead of securing the most beneficial price for RLSB, he allowed the company to overpay. He also breached Section 218, Clause 1 by using his position to obtain personal gain, and Section 219, Clause 1 by failing to disclose his personal interest in the transaction. Furthermore, Ravi action constitute a serious breach of fiduciary duty as he made a secret profit without the knowledge or consent of the company. Ravi conduct also involved a significant conflict of interest, both under Section 218, Clause 1 and under common law, by acting as RLSB's representative in the transaction, while at the same time receiving a secret financial benefit from Maju Berhad. Ravi was serving two interests that were in direct conflict. His personal interest in receiving the commission was incompatible with his duty to obtain the best deal for RLSB, as highlighted in Aberdeen Railway Com. v. Blakey Bros. Such a conflict of duty and interest is it itself a breach of fiduciary duty even if the transaction appears fair or profitable for the company. In the second scenario, Ravi received confidential information regarding a land development opportunity in Ipoh in his capacity as a director of RLSB. Instead of passing this opportunity to the company, Ravi and his fiancée Samantha incorporate a separate company, Mikasa Sunyan Berhad, MSB, and use the information to purchase and develop the land themselves, generating significant personal profit. This is a misuse of company information in breach of Section 218 Clause 2 CA 2016. Additionally, it constitutes a violation of corporate opportunity doctrine, which prohibit directors from taking for themselves any business opportunity that arise due to their position within the company. This is similar to Regal Hastings Limited v. Gulliver and IDC v. Cooley, where directors who use company opportunities or information for personal benefit were held accountable. This conduct also clearly involved a conflict of interest in breach of Section 21 and 218 Clause 1 CA 2016 and Common Law. Ravi had a duty to disclose the opportunity to RLSB and allow the company to decide whether to pursue it by secretly using it for his own benefit. Ravi placed his personal interests above the company's, which is a serious violation of his responsibilities as the director. Conclusion. In conclusion, yes, Ravi has breached both statutory and fiduciary duties as a director under the Companies Act 2016 and Common Law. His action in accepting a secret commission and misusing confidential information for personal gain through Mikasa Suryaberhad demonstrate clear conflicts of interest and non-disclosure and unauthorized personal enrichment. Therefore, RSLB can take legal action against Ravi and seek remedies such as account of profit or recovery or secret commission and profit from the IPO deal, damage for financial loss, rescission of the Maju Berhad contract if proven misrepresentation, injunction to freeze asset, constructive trust over the profit made, removal of Ravi as director under Section 206 CA 2016. RLSB has strong legal ground to hold Ravi accountable and to recover losses caused by his misconduct.
Dato Safik, a director in Mani Mani Sendirian Berhad, has done the following. He rarely attended meetings and often delegated his duties to his subordinate officers. He was awarded one of the company's contracts to his wife, Suraya, without disclosing the fact to the board of directors. He has bought a piece of land for the company and later kept the commission for himself. Advised Mani Mani Sendirian Berhad on whether they can take legal action against Dato Safik. The issues are whether Dato Safik, a director of Mani Mani Sendirian Berhad, has breached his duties under the Companies Act 2016 due to the following actions: failing to attend meetings and often passing his work to others, giving a company contract to his wife without telling the board of directors, buying land for the company but secretly keeping the commission. According to Companies Act 2016, directors must follow several important rules. Section 213 Clause 1, a director must act in good faith and in the best interest of the company. Section 213 Clause 2, a director must carry out their duties with reasonable care, skill, and diligence. Section 218 Clause 1, directors must avoid conflicts of interest between their personal interests and the company's interests. Section 218 Clause 2, directors cannot use their positions, company information, or opportunities for personal gain. Section 221 Clause 1, if a director is interested in a contract, they must disclose this to the board of directors. Delegation, Section 216. Directors can delegate, but they must make sure the person is trustworthy and competent. In the case of Cook v. Diggs, the directors took company opportunity for themselves. It is considered as breach of duty. Meanwhile, in the case of Mahesan v. MGOC Housing Society, the director took bribe during a land purchase. It is considered as liable.
In this case, Dato Safik rarely attended meetings and delegated duties. As a director, Dato Safik must be actively involved in managing the company and attending board meetings. Section 213-2 requires director to use reasonable care and diligence. Even if he delegates, under Section 216, he must still ensure the people he trusts are reliable and responsible. His behavior shows negligence and the company can claim that he felt his duty of care. B. In this case, Dato Safik gave a contract to his wife without telling the board of directors. Dato Safik has conflict of interest. Under Section 218-1, he must avoid putting personal interest above company interest, and under Section 221-1, he must declare his wife's interest in the contract at the meeting of the directors as soon as practicable after the relevant facts have come to his knowledge. C. In this case, Dato Safik used his position as a director to negotiate and complete the land purchase for the company, but later took a personal commission. This commission was not disclosed to the board or shareholders, and no approval was obtained. Even though the land was purchased for the company, keeping the commission for himself is a secret profit, which violates his duty to act honestly. He needs to avoid using company transactions for personal benefit. Dato Safik has clearly breached his duties as a director under the Companies Act 2016 in all three actions. A. He failed to attend meetings and did not act diligently. B. He gave a contract to his wife without informing the board of directors. C. He used a company land deal to secretly earn commission. The company can sue him for damages and claim compensation, ask him to return the profit or commission he took, and file a criminal report under Section 218-2 or 221-10, punishable with fine up to 3 million or 5 years in jail or both. Lastly, the company can apply for director disqualification under Section 199 because he has acted dishonestly. Directors must act honestly and in the company's best interest. Dato Safik's actions are serious breaches of duty, and Mani Mani Sendirian Berhad has strong legal grounds to take action
against him for all three issues.